So hello everybody, welcome to this session. And well, all of you know about how algorithmic systems are more and more supporting processes in decision making, and be it in government, in civil society, or in companies. And to address risks and issues that may arise in these systems, we can think about algorithmic impact assessment as possible accountability tools. That's going to be broadly speaking the subject, but maybe I'll give the floor very quick to Gianclaudio, who organized this session.
Yeah, thank you very much, Björn. So it's my pleasure to have all of you here. This topic will be, I think, extremely timely. We have been discussing this yesterday at the privacy camp, and there will be further events connected to the issue of algorithmic impact assessment. So we are quite dynamic because the moderator is 182 people. So actually, we'll just relaunch and introducing him. So Björn is the professor of business law and business ethics at EDHEC, Augmented Law Institute, hosts this panel, and is currently the head of faculty for accounting. So Björn, again, the floor is yours.
Yes, so I'll introduce the panel members. So we have from the University of Colorado Law, we have Margot Kaminski, who is associate professor there, and she's also director of the privacy initiative at the Silicon Flatiron Center, and she specializes in the law of new technologies. And in 2018, she researched comparative approaches to data privacy as a recipient of the Fulbright Schumann Innovation Grant. We have another lawyer, Gianclaudio, who is associate professor of law and technology at EDHEC Business School. So in fact, he has his office just across mine. So we're at the same institution, where he conducts research at the Augmented Law Institute. And he got the PhD at the law at the Free University of Brussels, where he is still affiliated researcher, and he is the editorial board member of Computer Law and Security. But don't worry, we don't only have lawyers with us on this panel. We also have somebody who is from the technology side. We have Hendrik Junklewitz, who is a research scientist for machine learning at the Joint Research Center of the European Commission, providing research and scientific policy support to European policy makers. His research focuses on the robustness and explainability of machine learning algorithms and the interplay of cybersecurity and artificial intelligence applications. And then finally, we also have somebody from the business world. We have an entrepreneur. We have Olivier Guillo, who is the founder and the CEO of Smart Global Governance. Maybe you've heard about the company. If not, Smart Global Governance is a publisher of productivity software solutions for ethics, compliance, and control. So, in other words, Smart Global Governance helps individuals and organizations achieve more compliance and ethics. So I'd like to open this round. First of all, before we come to all kinds of legal issues and business issues, I'd like to open the round with technology, so that we can frame the discussion. We can see what is possible, where are the limits. Already announced we'll be talking about algorithmic impact assessment as an accountability tool, but I think that Hendrik can give us some insights on what are the prospects and the limits of these tools. To give the floor first to Hendrik.
Thank you, Björn. Thank you, Gianclaudio, for the introduction. Waiting for my slides. And well, there they are. Thank you, CPDP, for inviting me, of course. I can already start while the slides are loading, I guess. Yes, I will be sort of setting the scene for this panel from the algorithmic side of things, and provide a few more technical viewpoints on automatic decision makings, and ultimately where this leads to algorithmic impact assessments. So I'm going to talk about algorithms briefly. I want to focus on AI algorithms in this setting. Let me just add that not all algorithmic decision making is AI, but I nonetheless focus on AI algorithms because especially the subfield of machine learning in recent years has advanced the field a lot and is posing complex new issues to the topic of impact assessment. And so machine learning is a part of AI where actually data is used twice to train the algorithm, and then later it is applied on new data to predict an outcome. So I'm not sure if people can see my slides because I think it's dark. Anyway, so I guess I move on. So there is one big challenge from machine learning to all of this, which is a trend to ever increasing complexity. We are seeing more complex data and more complex algorithms, and this inevitably will lead to more complex explanations. So it will inevitably lead to systems that are harder and harder to explain and to describe. So we have seen this. We've seen this development going from where we're used to standard data in tabular form and often rule-based systems, or something very clear and transparent, like a decision tree that sets a rule and from which we can make a decision on the system automatically. But we're moving now to much more complex data. One example I want to delve in is image data, where you, instead of just the tabular data, have images, and you run usually complex algorithms like deep neural networks on them to classify objects and make decisions on that. And even for experts, these type of systems are becoming increasingly complex and unexplainable. Often they're used as black boxes. They're just what is called predictive modeling, and often in cases, so you are just looking at correlation and association in data, and it's hard to really pull down a causal link of all of this. So you could ask, why is this a problem? Probably not at this panel, and I'm probably not the best expert to delve into the part of data protection and fundamental rights of this, but let me maybe give you a few pointers from an interdisciplinary technical case study we have conducted at the JSC together with Gianclaudio here in the panel, where if those systems that are much more complex are actually being used in automated decision making, and they increasingly are. Oh, that's nice. We're on slide 3. Exactly, here we are. So here you see the work cloud that represents our paper that we just published. So what I wanted to say is these more complex algorithms, if they are used to process personal data, of course they fall under the scope of the GDPR, and this means all the safeguards that are put out for data controllers apply to them. Like, you need to be able to provide a meaningful information about the logics involved. You need to be able to justify the outcomes, or put the data subject in a way that they can contest the decision. All these things, and especially in high risk situations, this becomes even much more important, because there we even can have the right to receive an explicit explanation. So high risk cases, one of those we have explored is, for example, the medical realm. And what we have done, we have conducted a case study on COVID-19 image detection problem, where we put out the hypothetical scenario that a patient shows up at an emergency ward that is overcrowded. The hospital, there is no doctor available readily, but nevertheless you need to do a triage, and the patient has the chance to wait or to submit themselves to an automated decision-making system, which is now based on a deep neural network X-ray image classification, which you can represent it here on the slide. And this situation is even not so far-fetched as you might think. These type of systems are being tested and experimented on. Other AI-based systems are used in triage right now, or at least experimented with, and big tech companies put out publications in this direction, for example, Facebook. So we can imagine the situation, and we can imagine that the patient is faced with the situation, wants maybe to contest this decision, which clearly affects their well-being, And what we in the end concluded is that the quality of such explanations in such a complex deep learning based system might actually not be judged adequate under Article 22. So this is a problem, of course. You can see here, I just focused now because of time on the image. This is just a typical method to explain how which part of pixel regions in an image are important or not for the decision of a system, but clearly this might be completely meaningless to somebody without medical knowledge, and even with somebody with medical knowledge, this might be meaningless because this is basically pointing out associations that the complex algorithm has learned. There's no need that this has any causal link to the actual disease below this. So next slide, please. So what I wanted to do here is I wanted to make clear that we are having a problem and that we need to solve it from the technical side of things, because the big question is, how do we make the link between the technical world that and all those requirements we want to put up for systems to be under the scope of the GDPR and be fine under them. So I basically tossed the ball here to my panelists with this. I just want to stop with an opinion piece where I say that I think from what I presented in general, there is a monolithic approach to transparency and explanation coming from AI-based systems will not be productive. So I think we need to embed this in a larger frame. I want to cost the term trustworthy AI here. I can talk later about this. And we need to embed it, of course, into a proper algorithmic impact assessment. Otherwise, we won't be able to tackle these issues. And we cannot rely just on explanations for it. That's basically my point. And here I stop. Thanks for listening to me.
Yes, thank you very much. Thank you very much, Hendrik, and also for drawing up the limits and the problems of embedding this kind of system, also with the reference to Article 22 GDPR. I think that the GDPR has actually two layers, individual rights and systemic governance approaches. And I would like to hear from Margot how these, how we sort out tensions and between these two layers that are set out. Probably you're not only going to refer to the GDPR, but maybe more in general. How do we go about with these two potentially problematic relationship between individual rights and, on the other hand, more systemic approaches to governing AIA?
Thank you so much, Björn, and thank you, Hendrik, for that introduction, and thank you, Gianclaudio, for having me, and thank you, Olivier, for joining us. So I'm going to try in my 6 minutes to cover a little bit both the purposes and the processes that are involved in algorithmic impact assessments, and in the course of that conversation, to reference what Björn just referenced himself, the two layers of the GDPR working in concert through this mechanism, the corporate governance layer and the individual rights layer. So as backdrop to this, I've been doing work for a number of years now on the purposes of transparency and algorithmic accountability. So if Hendrik talked about the mechanisms of transparency and the technical challenges to transparency, I'm really interested from a governance side, from a legal side, and a design of regulation side on what transparency should look like and what transparency is for. Because in order to answer the question of what kind of transparency do we need to know why do we want transparency. So looking specifically at algorithmic impact assessments as a tool, I'm going to discuss them on a macro level and a micro level, and as I said, regarding the purposes and regarding the processes involved. So on a macro level, an impact assessment is a tool of risk mitigation. It's used in a number of different areas of governance, including in the United States, in the environmental context. The most parallel example in the US is probably the environmental impact statement that arises under US legislation. And it's been used previously in member states around the EU, even prior to the directive, just as the tool of a privacy impact assessment. So this risk management tool is intended basically to serve as a systemic approach to the problems of algorithmic accountability and to system-wide root out threats to data subjects' rights and freedoms. Now, that's interesting because when we think of individual rights and freedoms, we often think of accompanying individual tools, such as the right to explanation, or the right to contest an AI decision, or the right to express one's view. But the AIA, as Gianclaudio and I have noted in a paper published last year, is a systemic tool that's targeted at protecting individual rights. So from a macro perspective, it's a tool of risk management and risk mitigation, and the risks are to individual rights. Now, when it comes to a micro level of what the AIA does in the GDPR, I think that it's very important to note that this is so contextual to the European system. So when we look at examples of algorithmic impact assessments being proposed in other legal systems, such as state laws in the United States or proposed federal laws in the United States, or even laws in Canada, those are being proposed in a completely different context, a completely different regulatory context, where, as everybody here probably knows, the US doesn't have omnibus data protection law on a federal level and doesn't have the sorts of rights of access, the rights of correction, the rights to object to processing that you have in Europe due to the GDPR and a human rights backstop at both the European Court of Justice and with the European Court of Human Rights. So those acontextual transplantations of this risk mitigation tool really risk losing the substance that exists in the European context. Okay, so as promised, I'm going to get a little bit micro here and start talking about some details. It's important to understand the algorithmic impact assessment in the GDPR, both in terms of its purpose and the actual processes involved. So in terms of a purposive analysis, it's really meant to be something that gets at not just mitigation of risks, but also the infrastructure design of a company, how decisions are made in a company regarding high-risk processing. It's supposed to affect decision-making heuristics. So when a company sits down and decides, should we or should we not start using this tool, and how widely will we be using it, and using what kinds of data. The AIA process is supposed to purposively affect that to bring data protection squarely into the corporate governance sphere. It's also intended to purposively influence the design of technology before it's deployed. So it's both the design of a corporation and how it makes decisions, and the design of the particular technology before it is deployed on stakeholders and data subjects. Finally, in terms of the actual processes, Gianclaudio and I, in a paper, the same paper published a year ago, looked very closely at both the text of the GDPR in Articles 35 and 36, and the accompanying recitals and the guidance now from the European Data Protection Board, and concluded that it's actually a far more robust system of processes than one might think from looking at Article 35 alone. So the kinds of processes that are envisioned in an AIA, it's not just a document or a rubber stamp. It's intended to be something that requires ongoing, continuous analysis of a particular algorithm over time, which means that this can incorporate analysis not just of the algorithm or the AI before it's deployed, but also of its faults once it has been actually out there in the wild. It applies to high-risk processing. Again, high risk being determined with respect to individual rights and freedoms. There's intended to be, although not required to be, stakeholder involvement in determining what those risks are and how they might be mitigated. The data protection officer, so this is to the design of the company, is supposed to be involved with this risk assessment process. In some circumstances, though not all, there is government oversight in this process. And transparency is highly encouraged, though not required. So this is where I'll answer Björn's question and tee it up for my fellow panelists, which is that the AIA, as many know, is not actually required to be released to the public. Yet Gianclaudio and I have determined that the individual rights in the GDPR, in fact, link very closely with the kinds of information that's required to be put into an AIA, even if it is not entirely made public. And so as companies are conducting these risk assessments and producing these risk mitigation measures over time, they should be thinking, we think normatively, and as a descriptive matter of what the GDPR requires, about how to take those observations and feed them into the individual rights of explanation, the rights of access, and notification rights under the GDPR. So with that, I will leave it to my fellow panelists. And again, thank you, Björn, for orchestrating the conversation.
Thank you, Margot. You've already spoken about your co-author, so I'd like to invite now Gianclaudio to complement your speech. and maybe also talk a bit more about the GDPR and about data protection impact assessments, DPIAs, and possibly, if you can, also address, I think I would be curious about that, you can address the recent European Parliament resolution that also deals with, we have heard about high-risk situations, so you can also maybe refer to the recent EP resolution on ethical aspects of artificial intelligence.
Yeah, thank you very much, Björn, for this introduction. Thank you, Margot, for referring to our work. I should have some slides, so maybe they are coming. But I can, yeah, so, yeah, next slides. Yeah, the next one, if you can. Yeah, yeah. So basically, actually, just going directly to the point, we have a problem with black box, with opening the black box. So the first issue that we were all saying was, okay, we have a problem with black box algorithms. Now we can say that the 2.0 problem is the problem of explaining or arguing against the explanation of a black box. So, you know, as Hendrik was saying, we have a real problem of deep learning that cannot be based on causal explanation. So causation is not the way. Huh? And so, as Hendrik and Margot well said, actually we are now in a situation in which we really should look at the impact of algorithm more than just opening the logics of it. So of course transparency is fundamental, but in our view, so according also to the paper that Margot and I wrote, actually it's not just preferable to look at impact assessment, but this also somehow suggested by the GDPR. So here in this slide, you can really see the combination of data protection impact assessment requirements and transparency rights about automated decisions. So what actually Margot and I tried to do in this paper was just to compare the two sets of safeguards. As you can see, describing a data processing as required at Article 35, paragraph 7, perfectly matches with the need to express the logic, the meaningful information about the logic of the algorithm. But then it's not all there. It's also assessing accessibility and proportionality of the high-risk data processing. And I want to remind that among high-risk data processing, Article 35, paragraph 4, Article 35, in the first example of high-risk data processing, mentions systematic evaluation, and so profiling, of personality aspects or particular aspects of data subjects through automated decisions that have significant effect. So Article 35 already refers to situation of AI-based data processing and automated decision-making. So basically what we wanted to suggest was to use the tool of data protection impact assessment as a tool also to assess, and the verb is justify the algorithm. We need a justification of algorithm. How can we justify algorithm? In my view, the answer is at Article 5, the principles of data processing. If we look together at Article 5, we can find all the answers. We have the fairness, we have lawfulness, so the respect of requirements of Article 22. We have accuracy, but we have also purpose limitation, we have integrity. So a justification of algorithm, in my view and in our view, is a way to explain to the data subject that Article 5 is respected and that all principles are respected. But how? So the process to reach to this conclusion is a data protection impact assessment. So again, assessing necessity and proportionality seems very close to the showing the significance of the algorithm. Assessing risk to fundamental rights and freedoms is very close to show the envisaged effect of the algorithms. And mitigating the risk is very close to finding some safeguards as required by Article 22, paragraph 3. So you see, there's a hidden fil rouge between these two sets of safeguards that we wanted to highlight. And then next slide, please. If we put them together in this circle, we will find a nicer story about how describing the processing becomes something as explaining the algorithm, and also assessing risks becomes a way to justify algorithms, also through Article 5. And again, assessing risks is a way to mitigate risk, but while we can collect individual opinions through the right to contestation, this is also a way to redesign the algorithm again. But now, so this is the, how to say, the theoretical story. Let's look at one example, existing example, Canada. So next slide, please. In the Canadian, next again, we will skip this one because we are running out of time. In the Canadian example, we have the Algorithmic Impact Assessment as a reality today. So actually, this is already a law in Canada about algorithmic impact assessment, and there is this beta version, actually it's version 0.8, where you receive some questions, you have an algorithm, you have an automated decision-making system, and you as data controller can run this test. You can, and you have a practical tool, a practical framework to give answers and to assess the risk of your automated decision system. In Europe, this is left to the accountability freedom, let's say, of data controllers. There are some examples. For example, the Spanish Data Protection Authority made some relevant example about that in a recent opinion. So the Spanish Data Protection Authority actually linked the data protection impact assessment to artificial intelligence. That was our exercise with Margot. And then a new proposal, again, so next slide, is coming from the EU institutions. So this is also to reply to the last input from Björn. The European Union is also going beyond the GDPR, even though in my view the GDPR is already very complete and comprehensive. But so looking at we all know that there was this proposal from Ursula von der Leyen of the AI Act, okay? But the AI Act of the European Commission proposal is getting very slow, we can say. So the European Parliament, quite unexpectedly, tried to jump in, and they released this quite unconventional resolution, in which actually they attached a new proposal for an Artificial Intelligence Act. And very, very interesting, in the whole proposal, which is the proposal for ethical AI. So this is the name they use, which is very problematic and complex for lawyers to call a directive ethical AI, but this is another story. So looking at this in detail, and I'm going to close now, actually they adopt a risk-based approach. So the whole story of AI regulation in this new directive, in this new proposed directive, is based on risk. And how we calculate risk, we have two alternative models that are proposed. One is harm-based. So we see the impact on fundamental rights and freedoms, and we consider that artificial intelligence to be at high risk. And once you assess high risk, you have to respect some stricter rules on non-discrimination, bias auditing, and security measures, etc. The other index that we should use is the list of high-risk sectors. So AI used in health, AI used in energy provision, AI used in education, etc. So it's a kind of topic-based risk definition that is adopted in the annex of this proposal. I don't know if this is the right way to proceed. I think it's very interesting that this is discussed by lawyers now, because we are discussing a lot the GDPR, and it's fundamental to do that, but how to connect this to the AI proposal, and how the risk assessment proposed in this European Parliament resolution can be connected to the existing data protection impact assessment, or maybe if it's closer to the Canadian example, or to the AII example from the US, because actually the term AIA, Algorithmic Impact Assessment, was invented by American people. It's the first time that the privacy concept, maybe from the time of Warren and Brandeis, invented by American, and it has been fortunate in Europe. So I'm happy about this, North Atlantic exchange. So for now, I think it's all. Thank you, Björn.
Thank you, Gianclaudio. Thank you very much. So we have now listened to researchers, but I'm a bit curious now what people who are working with this from the business side, and in particular on legal tech, how they're picking all of this up, and what actually the state of art is when it comes to data protection impact assessments. And Olivier, maybe you can tell us, are you thinking about AIA as well, even in the European context? I'm a bit curious about this, so maybe you can give us some insights from your perspective as a CEO of a legal tech company that is very ahead on these issues.
Thank you very much. Yes, as a legal tech, we indeed look at AIA. Because we have got new regulations in Europe, like Digital Service Act, GDPR, and it's let's say a global project for protecting the interest of individuals in Europe. So let's say that AIA will be necessary first because organizations will need to use AI to comply with all the compliance frameworks they will need to comply with, not only regarding AI or GDPR, but also regarding ESG, regarding AML. They are overwhelmed by regulations and norms, and at the moment they can face the growth of their obligations, and since they cannot extend their budgets, their operating costs to comply with all they need to comply to, they need to use legal text based on AI to ease decision making. And by doing that, they will use AI as a solution for compliance, but it will also be a problem for them because they will need to assess the risk of AI for doing compliance. So just to give you an example of the compliance complexity the organizations are facing, just talking about GDPR, we've got the implementation of GDPR that is different in every European country. So when you look at that from a business perspective, and if you're an international company, it's a nightmare. And you cannot have, even if you have lawyers, even if you have a strong team, it's very difficult to understand the changes, the court decisions, the doctrine that changes. And for that, there are a lot of legal texts that are developing AI to assist organizations to make good decisions. That's one part of the thing. The second part is that with the new European resolution regarding AI, they will have new constraints in order to evaluate that the AI they are using is indeed benevolent for the society as a whole. And from a business perspective, it will be a similar process than for any regulation, starting with documenting, mapping the AI use, assessing the risk, documenting for transparency. And we have seen on the market organizations, mostly telco organizations, software companies that are starting to explore the way to assess AI algorithms. But for the rest of the market, they still struggle with Excel to comply with the other regulations. So it's really a faraway perspective for them. So if we look at this, in fact, Excel, what we observe in the market is that maybe 90% of the organization are using Excel at the moment, and the teams are organized in silos, meaning you've got teams for data privacy, you've got teams for AML, you've got teams for ESG, and at the end, if you look from a broader perspective, you notice that there are common points between these regulations, and if they were using AI or at least a collaborative tool more performant than Excel, they could identify bridges between the compliance frameworks, and by identifying bridges, they could mutualize the points of controls and the remediation tasks. So the market is broadly dominated by Excel. You've got solutions that are very strong in content. You've got solutions that are very strong in automating some points of compliance. And you've got new startups like that are working on high automation, strong content, and AI as a tool for decision making.
So thank you very much, Olivier, for these insights. That yes, legal tech can help companies better manage compliance issues, including the ones we're talking about right now. I see there are a lot of questions coming in. There are some questions coming in here, but before we come to the audience questions, we'll have time for that. I would like to do one more round with our speakers, because now the panelists have all heard each other. And possibly I would like to give, first of all, the panelists a chance to react to what has been said. And I'm going to start again with the technology. Bring the ball back to Hendrik, who can maybe look a little bit ahead in the future after you have listened to all this, how algorithmic impact assessments can be relevant in carrying out duties under the GDPR, for example. Can you look a little bit more in the future, how we can, beyond explainability, achieve trustworthy artificial intelligence? I'd be interested in that question. Maybe you have something to say on that, Hendrik.
Yes, sure. I basically can complexify the whole situation a bit even more. So of course, I like the what I heard a lot, that basically we're all talking about that risk-based approach is the right thing. What if what I also wrote on my slide, I think we need to move away from a single way of judging how an algorithm has an impact or not. But I guess we're doing that. But in that, so we need to delve, in fact, deeper into the complexities of especially if you're looking into the future of more complex AI and machine learning algorithms. And there's a lot to say there. That's why so trustworthy AI is a term put forward by various actors, especially also the high-level expert group on AI put forward by the European Commission, that instead of talking about singular aspects of AI algorithms, that we need to talk about a number of them. Like, it's not only about explainability, you also need to think about robustness and safety, about security. There are huge cybersecurity issues also involved with AI algorithms in certain areas. It's about fairness. We have at this conference, I've heard a lot about fairness, of course, diversity, non-discrimination. We have not really come to this, but if I may use just a few words on, so all of these things get complex if you really look into the details of algorithms. For example, I was just briefly going over this. We have, what I said, increasingly complex data, increasingly complex models. This doesn't stop with image data. This is not even the most complex data you can imagine. There's combined data fusion going on with various data streams, text and image data, video data. And then there's also a third element to this. We are not talking about only complex models like a neural network that might be very complex and hard to understand. We're also having algorithms to train those models that get more and more complex. We have concepts like data augmentation, where machine learning engineers actually change the data sets themselves in order to enlarge them and train their algorithms better. And all these things get even more complex because it's hard to assess the performance of these algorithms because of so-called generalization issues. So you train these algorithms on certain data sets, then you get performance numbers. I heard Gianclaudio talking about performance and accuracy as one element put forward, but we even can't entirely promise accuracy of these algorithms. We've trained them on a certain type of data, and there's no way to say in future, if I apply it to other data sets, that this accuracy will hold. At least not in the current situation. Then, to me, what is also interesting is if I talk about risk in this context. So, what about situations where I don't know? I think we need to go and see how these things might not be together possible. For example, let's take this medical imaging example. Let's say it's life-saving, but it can't be explained. So, is this still acceptable? Under what circumstances would we allow such a system to be used? How robust does it need to be in order to that it is in concrete terms? And how do we prove this robustness technically? This is not easy. This is not easy for a machine learning engineer to give you a definite answer there. Yeah, I could go on, but I think I don't know about the time. Do I have more time?
Well, we don't have very much time because I would like
Then I leave the floor to my panelists. Actually, maybe we can also have an interaction if there is a question to what I just said, or maybe one last thing. I was very interested by what Olivier said about that AI is going to be needed to do the assessment, and then we need to assess. That's actually really quite a vicious circle.
Yeah. So if I'm permitted, I'll go next. So what I wanted to add to that is that I think we need to not forget, one of my favorite papers actually makes this point, that while AI might be a black box, corporations are certainly not. And we have a long history on both sides of the Atlantic of figuring out methods of corporate transparency and corporate responsibility or accountability that go beyond just the question of, can you describe the technical aspects of the thing that you are using, the tool that you're using? And those kinds of tactics, very much as I understand it, as Gianclaudio understands it, are intended to be part of the DPIA process. So we're not just looking for making the technology, the black box, explainable to individuals, which in some cases, as Hendrik notes, might not be technologically feasible. So I'll table that question. But we're looking at making the corporation's actions, or in the case of the EU, the public agencies' actions, also transparent and accountable. So this includes things like, as I mentioned in my presentation, involving stakeholders early on in the design of technological tools, requiring recording and reporting requirements within a company, structuring infrastructure within the company so that there are independent agents, as the Gdpr requires, the DPO, who is responsible for raising issues around the regulation around individual rights and freedoms, independent of sort of the company's desires. And so what I'd say is that it's very important to remember that not only is the AIA primarily a tool of corporate accountability and responsibility, it's also only one tool among a lot of tools in the GDPR. So this brings me to my second brief point, which is that while I'm glad that the US has been influencing the EU, according to John, I would say that I hope that the influence runs in the other direction. My aim is that the influence runs in the other direction, because the proposals for AIA in the United States, at least, have largely been entirely acontextual. They have not included these other rights and these other regulatory tools. And so that means that it runs a greater risk of being a sort of empty checkbox of compliance. And so with that, I'll come to, I said I'd have 1 point, or 2 points, but my third point, which is that I am very skeptical of the idea that you can automate compliance around an AIA. And that is in part because of, as Olivier noted, the deep complexities of the underlying legal rights and how difficult it is to automate assessment of underlying legal rights that are not yet even fully developed themselves or articulated as standards, but also because I think the AIA, as I've noted, is a process. It's about corporate governance. It is not just intended to be, a checkbox that says, or really terrifyingly an Excel sheet that says you have or have not done these particular things in one document.
So maybe you can hear, because you were talking about you can't automate compliance, and that is part of the business model, if I understood correctly, by Olivier. So maybe Olivier, you want to bounce back on that about to which extent we can in fact automate compliance, and in fact to which extent legal tech
Yes.
can bring this idea of also using AI to evaluate AI and to assess AI.
I think that if a company would pretend that it could automate compliance through AI fully, then they would be liars. It's not possible at all, because there is at a point decisions to make, and they can be let to be decided by AI. That's the first point. No, the point that what can be automated is all maybe the workflows, all the the repetitive tasks to notify again colleagues that they should fill the gap analysis, they should fill the documents to assess the risk. That can be automated. What can be also automated is the gap analysis, probably, or most of it, with individual supervision by a compliance officer. What could be also automated or facilitated by AI is helping making decisions. We all know that the human brain is limited. I think it's the Miller law, between 5 to 7 parameters when we make a decision, and probably where AI could help is to help us create scenarios. What would happen if we decide to do that, and that is where AI can help. But honestly, a part of that, we will always need compliance officers, internal auditors. They could use AI to help, but AI cannot replace a human for compliance and control of compliance.
Yes, thank you very much for this clarification. And I was thinking about what Margot said of thinking about corporate governance aspects of this subject, and of having stakeholders participate in the design of AI that is used in whatever context, in a commercial context, for example. That brings us really to some intricate policy questions. And well, maybe we can have Gianclaudio. Maybe you have a perspective on these issues, looking forward to the future of policy making in this regard.
Yeah, thank you very much, Björn. I think I would like also to connect your question to a short reaction to what Olivier and Margot said about automation of compliance, because I think even yesterday we were discussing this topic of algorithmic impact assessment, and there was a nice provocation about the top-down approach or the bottom-up approach. And I would say that in a top-down approach, it's very important to give some framework, some clear framework on how to assess risks for AI. So the future of policy making, I would say, it's giving a clear framework on how to do things in practice and who should check. I hope a world in which data protection authorities cannot just block TikTok because there is a scandal in the media, like in Italy, but because they really think that they might give a handful help to the data controllers that really are lost in this flow of impact assessment, fundamental rights notion. An average controller has not clear view of what is happening. So again, to the top-down and bottom-up approach, I would say that for small companies, it's good to automate compliance as much as possible. But for big companies, I would hope to humanize the automation as much as possible. We should talk to Google, we should talk to Facebook, we should talk to Amazon, and so on and so forth, and also to the medium tech, to try to understand and to make transparent the circle of impact assessments. Algorithms should be understood by them, algorithms should be assessed on practical cases, and statistics should be the best way. So showing numbers, showing correlations. So to connect also to Hendrik, we need to know what are the correlations used and what we really want. And I hope for the future of policymaking, if I had the power to influence it, I would say that the real challenge is to make algorithmic decision-making non-justified by default, so that data controllers have a positive duty to justify them. So non-default, they are, we can say, unlawful, and the data controller has a duty to justify why these automated decision-making systems are fair, legitimate, or lawful, transparent, and so on and so forth. And so they should show why they are not discriminatory. So the burden of proof, using a lawyer dictionary, should be on the data controllers. Of course, the small ones have no power to do that, but that's where data protection authorities should step in and help. Data protection authorities should have a meaningful role, like the ICO is trying to do, like the CNIL tried to do with the PIA software, but that PIA software is very, very minimalist. I would suggest not to follow that example, or the Spanish one is doing. So I really hope this might be the future. For it's not just policy making in terms of law; it's policy making in terms of soft law. We need more soft law, but more clear. Also, if you look at the EDPB, and then I will close because I think we should leave some time to the discussion of Q&A. But if we look at the European Data Protection Board, their opinion on profiling, okay, was wonderful because was quite comprehensive and very timely because it was approved before the GDPR came into force. But it's not enough. They had an annex. Yeah, they had an annex in the end, in which basically they were proposing some possible questions that the data controllers could ask to themselves. It's not enough. This question should be more precise, and mostly what I was trying to ask also yesterday, to say also yesterday in a similar venue, we should really have a list of harms produced by AI. So we should know what a risk to a right is. Okay, we should know who can be injured by an algorithm and what does it mean. So some examples. There was a Future of Privacy Forum list of harms last year. Not last year. It was a document of 2017. But it was not comprehensive, not exhaustive, but the first attempt. I think we lawyers should work at that together with technical people and also legal tech business people to understand how we can translate fundamental rights in harms. And these harms, once we know that, we can do a better impact assessment, and we can really make an algorithmic impact assessment in the best way possible. So, yeah, I think that's.
I know we're supposed to turn to questions. I had just a quick augmentation to that. So Gianclaudio has done, as many people know, some pretty fantastic work looking at member state implementations of Article 22. And what's interesting is that there's variations between member states in how substantive they are, how much they talk about what the substantive harms are in algorithmic decision making. So this is not just a matter, once again, of sort of soft law or corporate compliance. It's also a matter of legal design. So as member states are deciding to implement Article 22, this is an opportunity to, if they have not yet done so, this is an opportunity to really think about incorporating a substantive backstop that addresses the harms of AI.
It is good, Margot, that you bring up Article 22, because that offers me the opportunity to make a very smooth transition to the questions that I'm getting. So I have here a question of exactly on Article 22. So for all those who don't know what I mean, Article 22 is about automated individual decision making, and the question is, how do you envisage a further interpretation of the application of Article 22 GDPR? So that is the question that comes from Aida Ponce de Castillo. Maybe maybe that's something for, but it's not only a question directed to the lawyers, because I guess also the business side and Hendrik have something to say. So on this.
I'll give a.
Yeah.
I can give a very brief response, which is that I have a lot of papers. So one is on the right to explanation, and another is on understanding transparency and algorithmic accountability. And the third, which is forthcoming, it's not yet public, is on the right to contestation. Substantively, what I'd say those papers do is articulate the centrality of and the lack of interpretation of the contestation right. I know that there are some scholars who have looked at it, but it's pretty minimal. And so vis-a-vis Article 22 itself, there needs to be more discussion of what it means to be able to contest AI in practice than just reverting to these existing discussions of algorithmic transparency.
Yeah. If I can add just 2 words, so about how implementing Article 22, you know, the word implementing is problematic in Europe because implementation is used for directive, but let's say specification of Article 22. So basically, you know, I had, as Margot was saying, I had the opportunity to look at several member states' implementation in the first year of the GDPR into force, and actually there were some very relevant insights that other member states could copy in implementing Article 22. First of all, I would suggest looking at the UK Act. Okay, it's not EU anymore, so we are free to copy, no plagiarism. Actually, in that case, they proposed a procedural, I would say procedural explanation. So basically, once you have your contestation done, and this is to follow up with Margot about contestation. So once you contest, the data controller in UK is obliged to explain you the steps taken to comply with that contestation, and whether he or she agrees or not with the automated decisions or with your contestation. This way, as you can really see, we have a post hoc process of explanation built in the dialogue within the data processing, between the data processing controller and the data subject. Of course, not easy, very few data subjects would act that way, very few data controllers would start this, but it's still a first grade point. And a second example that I would suggest is France, even because now France is my new my new homeland. Basically, in France, there is a clear legibility requirement, and so it reminds back to a paper quoted with Professor Giovanni Comandè, in which actually we try to look at legibility, and under this perspective, the French example is extremely relevant because they really give an insight on which are the parameters that should be disclosed to the data subject. Also interesting, the Slovenian one, and I'd close about implementation, because in the Slovenian example, which was just a proposal, was not yet approved, and now that law is not yet a reality. So it's a really, you know, soft law, we can say. There was a proposal to do human rights impact assessment. I would suggest to refer also to a work from Helene Jansen about fundamental rights impact assessment, because she was trying to link fundamental right and impact assessment, as the Slovenian example was trying to do. Not easy again, but it's really up to the regulators. I'm very sorry that national regulators have other priorities, totally other priorities. When implementing data protection, they just copied their previous privacy codes, and that's what they did for research, for medical diagnosis, data processing, statistic data processing. I didn't find great novelties in national data protection acts. Apart from the French one, which had a lot of, you know, also another loi informatique, sur République numérique, but it was not the GDPR implementation, it was before. So it's like in parallel, having this post-mortem privacy, etc. Yeah, but of course, I cannot be exhaustive on all member states. So I will just try to say that more work.
So, thank you very much, Gianclaudio. By the way, I have some remarks from people coming in that they are interested in the references and in the papers that Margot and Gianclaudio that you have been mentioning. I don't know if the conference organizers, if there's any way to communicate all of these references, because it seems that the people here would very much like to read the papers that you have been mentioning. So if there's, I'm sorry, I don't know how we can share these references in this form. I hope that there's one way that the conference organizers can establish the communication between Gianclaudio and Margot in this respect. Gianclaudio, he has mentioned Well, maybe Gianclaudio and Margot, you can put some pointers and references in the chat. That could already be one way to solve that request from the people here.
Yeah.
And if Gianclaudio, you mentioned working with Giovanni Comande, who's also a question here. He's with us right now, and he has a question I think is quite important. Maybe it didn't become clear in the presentation so far. He says that should an algorithmic impact assessment also be able actually to look at the quality itself of the algorithm? So whether it contains, for example, biases, whether the quality of how the algorithm actually integrates fairness, debiases processing and tests used for the training of data sets, and otherwise. Also, there's a reference, Giovanni makes the reference to AI. Does AI presuppose and analyzes without guidance? And refers to the Canadian questionnaire as an example. This is maybe also a question possibly for Hendrik.
Yes, so sorry, I'll be really brief. There definitely is a substantive content, as Professor Comande well knows because he wrote about this, substantive content to the AIA, which I think can be garnered from a combination of the larger regulatory context in the GDPR of protecting fundamental rights and freedoms and what that means, and also from Recital 71, in which the recital specifically articulates concerns about error, bias, and discrimination, and decisions based on particular categories of sensitive information or special category information. And so, yes, there is a substantive hook. I think when you look just at Article 22 or just at Article 35, it can be hard to determine that substantive hook solely from the text of the GDPR.
Yes, so I can just quickly say that this was actually some message I tried to bring home when I was mentioning the trustworthy AI keyword, that we should not look only at one of these aspects, but we have to, if we analyze algorithms for how impactful they are, we need to not only look at the right to explanation, but at other rights too. And of course, fairness is an extremely important topic. And others too, security, safety. If you go to other algorithms, especially when you go to imaging techniques or object detection, face recognition, all these topics, then that becomes very important. So yes, so I can just completely concur with that comment. From the technical perspective, at least, we should for sure combine those in a risk-based approach.
Yeah, I mean, I would not add much more. Just saying that actually, checking biases and analyzing biases requires, of course, a certain knowledge, at least, of the algorithm factors and the categories of data within the process. So we cannot really detach our discussion from the black box system, of course. Maybe the way is just that looking at the impact of the algorithm is also a way to understand how the code is working. Not how the code looks like, but how the code is working, which is what we need. We need a practical justification of the effect of the code. So actually, this was, I think, a point that was raised many times. But, for example, just because if we look at explanation as it was applied today, for example, for Google, there was the what if tool applied to from the counterfactual explanation paper from Wachter and others. But in that context, it's one way. So we know the counterfactual, but we are losing a bit of context. We are losing the general picture of whether there is discrimination in place, where accuracy is guaranteed, etc. So I would really go for this non-justification by default. I'm sorry to repeat myself, but I think this might be something that could solve also this issue. So looking at the impact as a way to look at the story of the algorithm.
And I'll add one more thing, sorry. I think it's also a really important reason why stakeholder involvement needs to be considered, because when we talk about things like bias or discrimination, there is a legal definition to that, but there's also a legitimacy concern. And if you are deploying an algorithm without taking any sort of assessment of the impacted group of stakeholders, then you're missing sort of the legitimacy component of ensuring that there is no discrimination. And you may, as a company, have one idea of what bias means, and your impacted stakeholders may have another idea entirely.
Yes. I would also like to point out one thing that in my work, I work on human rights impact assessments, and then according to the United Nations guiding principles in that respect, it's also stakeholder involvement is a key aspect there as well. So why shouldn't it be a key aspect in this context? Indeed.
I can also quickly point out one more thing, which is some of these aspects might actually be also, at least on the technical level, not that they might be playing against each other. For example, there's a raging discussion in the technical sphere that accuracy and explainability in algorithms might be not always achievable on the same level. So some of these black box deep learning systems are precisely designed to be very accurate, but they're not very explainable. And there is a discussion about this. This is a big topic, but it might also be that some of these aspects cannot be fulfilled to the same level at the same time on the technical point. Yeah.
So I see here that Gianclaudio has shared some of the references that have been pointed at during this discussion. I hope everybody can see it. We still have some time, if I get it right. We still have some time for more questions. How many minutes? 2 minutes. This might be the occasion to share nice feedback from somebody in the audience, Peter Hense, who thanks Margot and Gianclaudio for the work that they have already implemented AIA, your suggestions and recommendations into practice. So do you feel confident about that, or does it rather worry you?
Oh, it's fantastic. It's fantastic to hear. I'd want to hear more about the details of implementation and what that looks like. I think the big question for everybody is, we need case studies. And so the kind of work that Gianclaudio and Hendrik are doing, and probably the actual implementation in your companies, it really matters for us to learn about that as academics.
Maybe Olivier, can you comment on practical implementation of AI in practice?
Yes. So basically, the organizations need to be fed from works from academics in order to define the framework, because at the moment they are not really, let's say, a common framework for all organizations. So the way the legal tech handle it is to offer solutions for organizations to digitize quickly surveys, create rules, and then to try to analyze the answers as automatically as possible in order to, let's say, to have first results and then try to improve the framework. And indeed, there are communities that are being created at the moment of organizations. For example, in France, with an organization like Cercle Montesquieu, that meet to try to make new frameworks based on first insights from academics and eventually EU resolution.
Thank you, everybody. I think I'm getting the message here that time is up. So once again, thank you for the questions from the audience. Thank you, the presenters of the panel, for your very valuable insights. And so I hope that this was informative. You still see the references on the chat box, so don't hesitate to copy and paste them. That's what I always tell my students: don't copy and paste. But here I encourage you to do so. So that you have the references. So thank you once again, and also for the organizers of the conference. Have a good evening.
Thank you very much.
Bye.